And we are back. Welcome back to Something Else Today podcast, aka Said Podcast. I am your host, DJ Mahlatse. And you know, every week we're bringing you something else. And this week we are talking about labor law and road accident fund. And we have a guest joining us. And the name of the guest is Benedictus Dlodlo. So, hi, welcome.
Hello, madam. How are you?
I'm good. How are you?
Nice to be here. Thank you.
Great. How was your drive here?
It was not that long, just 30 minutes away.
30 minutes away. Okay. That's good. That's good to know that it's not that long, so we can invite you for other segments.
Yes.
Definitely. So we're going to get into labor law first, and then we are going to move on to road accident fund. Can you tell us a bit about yourself first, your background, the legal firm you're currently running as well?
All right. I started practicing law in 2018, so I'm 8 years in the game now. But Benedictus D Incorporated as a boutique law firm started in 2022. We specialize in commercial and corporate law. We also our expertise in the field of labor law and RAF and general litigation. By general litigation, we're talking about divorce matters, civil litigation. We're talking also about RAF, as you've mentioned. But we are not limited to such.
Oh, okay. That's great. That's great to hear. So I'm sure this is going to be very, very informational. So in terms of your school background, what about that? Please do tell our audience.
All right. I went to the University of Zululand, that is in KZN, situated at unpacking. Graduated in 2016. And then I went to law school in Limpopo. And then after 6 months of that's when I got my articles in 2018. And then I got qualified as an attorney of High Court in 2022, if I remember well. Yes. And then that's when I opened a law firm in that regard.
I did a degree and finished while you were still trying to. Yeah, that's great. That shows that, a lot of dedication and hard work to actually get the legal stuff going. So
yes.
So now you said you've been practicing law for 8 years.
Yes.
And then you've also told us which areas you focus on. So what inspired you to become a lawyer?
Well, when I was in high school, I actually had two options. The first one was to become a pilot. But unfortunately, due to my eyesight condition, that was now taken out of the bracket. So I was left with being a lawyer, or an attorney rather, because of my good orating skills. So I thought to myself, the second option would be considered as plan A, then I went forward with it.
Okay, so if it wasn't because of your eyesight, we would not have you here today.
Probably.
You must thank those genetics, eh?
Probably.
So I did some research as well. So it says LRA, Labor Relations Act, regulates relationship between employers, employees, and trade unions. It promotes fair labor practices, rights and responsibilities of the parties involved, conflict resolution for labor disputes, and encourages workplace democracy through employee representation.
Yes.
Also making sure work conditions are fair and employees are provided with enough resources to perform their jobs.
Yes.
So can you please tell us about the importance of having a trade union in the workplace?
Well, the importance of having trade unions is basically to safeguard both individually and collectively the interest of employees. Most of the employees don't know so much about their rights, and therefore sometimes the bargaining council or the trade union may send someone who's referred to as a steward. That person will there to manage and safeguard the interest and the rights of the employees. It could be from grievance matters within the workplace. It also could be as matters in the CCMA. So that's what the bargaining council, or rather the trade union, is important for.
So what happens? How do you navigate a workplace without a trade union?
Well, most people or employees actually are without one. Hence now, when they are facing labor issues, they have to approach private lawyers to litigate on their behalf. If they don't, they would rather have what we call a legal insurance, in which they are paying amounts like 100, maybe to 500 rand per month for legal representative. But those who are actually smart enough to take upon themselves to join the trade unions, they are safeguarded in that manner.
So you can join a trade union outside of work. Is that what you're saying?
Yes, you can. As long as you are employed.
As long as you're employed, regardless of which sector you're in.
So now, with trade unions, they are here in different sectors. For example, we have trade unions based on steel, trade unions based on mining, trade unions based on retail, trade unions based on teachers and education in that platform. So, but also we must put into regard that merely by registration, it does not mean that particular union has now a legal standing to protect an employee. Unless the requirements of such registration are enshrined within the constitution of that trade union, and the rights are therefore inscribed in that constitution, they can therefore have a legal standing to represent employees.
So if you are joining a trade union outside of the workplace, do you have to be paying it monthly, like the legal, legal package that you take maybe?
Perhaps if I may get you straight, what do you mean by outside of the workplace?
So for example, like we said, you don't have a trade union in the workplace, right? That represents everybody. And you take it upon yourself to join a trade union outside of, you said there's trade unions for teachers and all that. So you actually source one. Maybe if you're a teacher, you source one that's for teachers and you join it. Are there fees associated with you being on a trade union that is outside of your employer? Because normally it comes as a package, I believe.
But employers, you must remember, they try by all means to avoid this because they have a certain amount that they need to pay as well for the benefits of employees. And because they understand that there could be hurdles when it comes to labor issues where trade unions can be triggered coming to protect the interest of an employee. So that's the nitty-gritties that they're trying to run away from. But yes, employees can actually join a trade union outside their companies.
That's very, very interesting. So how do you describe a fair dismissal procedure?
Now, we have two principles that we have to look at. The first one, it needs to be procedurally fair. What do we mean by that? An employee needs to be afforded a right to defend themselves. What happens then, as soon as there's an issue or a misconduct that is alleged against an employee, the employer must give a notice of appearance to a disciplinary hearing. By standard procedure, they're usually given 48 hours to prepare their case. And then the notice should have the rights of the employee enshrined within the document. The right to find witnesses, the right to be represented by a co-worker or by a shop steward from the trade union. And number two, after that is afforded to the employee, we have to look at what we call substantive fairness. In terms of substantive fairness, we are looking if indeed there was a misconduct. That should amount in order for us to drive a disciplinary hearing in that regard. So both must go together. And what employers are unaware of, they usually get punished even though there is a misconduct simply by failing to run a procedure within the organization. So even though there is an egregious matter within or a misconduct within the workplace, failing then to allocate a disciplinary hearing for an employee could be punitive to the employer.
So you spoke about something about them, the right to have a witness, right?
Yes.
The right to have someone represent them, even if it's who represents them there,
It's
a lawyer or...
It's one of the trade union.
Okay.
It's called a shop steward.
Shop steward.
Yes. That one is actually being allocated by the trade union to manage the interest and the rights of the employee.
Okay, so... Wow. So what is being provided with appropriate resources and equipment look like? Remember when we read the LRA Act, we were reading about, that also making sure working conditions are fair to employees and they're provided with enough resources to perform their job. So what is appropriate resources and equipment look like?
Well, that's quite simple. Thank you for that question. It's basically to say that, for example, if you're going to hire someone as a security, as an employer, you have to provide a uniform. If you're in a VIP security, you definitely have to provide whether it's ammunition in order to whether it's vehicles, anything that will enable the employee to function in an efficient and timeously manner. Could be a desk, it could be a chair, it could be a computer, depending on the industry of work that you are dealing with. There is a responsibility from the employer to provide those tools in order to enable you to reach to the target, or rather to complete the responsibilities that you're given.
And if they're not provided, then that means that leaves a legal loophole when you do a fair dismount.
Yeah, it does leave a legal loophole because you might end up finding an employee being in a situation where they are frustrated and also they are expected to complete their task timeously. It's an unfair labor practice in that regard.
Yeah. Hi, let's move on to grievances. How and when do you file grievances in the workplace?
Well, whenever there is an issue within the workplace, whether by an employee, seniors, or whatsoever. Now, how do we go about it? Sorry if I'm going ahead of you here.
It's okay.
So, how to go about it? It's quite advisable to speak to your immediate seniors or supervisors about it. Um, some of the issues when it comes to grievances, they could actually be dealt with by a simple verbal apology or just reprimanding the two. Failing which, then, that's when it can either be taken to the CCMA or it could be internalized and a disciplinary hearing may be triggered in that manner. But also, it will depend on the kind of misconduct that has been committed within the workplace.
But what gets these? Because people are normally like very skeptical for on filing grievances. So what makes them not to go resolved? Is it because is it lack of, enforcement or leadership within the workplace, or is it just because this one is just the problem here?
Look, first and foremost, it could be power dynamics. If the perpetrator is your senior or your director, you know very well that if you report this, you might be risking your job. You understand? So, and number two, it's also cultural beliefs. Like you've just mentioned now, okay, culture without actually analyzing the situation as such, which can impair someone's dignity within the working environment. This can be verbal, this can be digital, and this can be physical. So with all this that I've mentioned, I think people also have a fear that if they do report this, they might appear in some way against their employees or their seniors, rather.
But isn't it now an unfair dismissal if now something happens because I filed a grievance in the workplace?
It is unfair dismissal, is that correct? And if you're not dismissed, your seniors or whoever might create an environment that is very frustrating for you, and thereby you resign. In that particular order, we can call it constructive dismissal, because they intentionally caused an environment that is so unpleasant for you that you have no other choice
but to resign. So now we're taking this to the CCMA.
Now we can take this to the CCMA.
So this is some of the reasons why people file cases with the CCMA?
Yes.
What other reasons are there?
Well, the other is unfair labor practices, discrimination, like we've mentioned. There are many other reasons. It could be unfair treatment at work. It could be based on racial slurs. It could be based on any other manner. It could be harassment to start with and other place, as I've mentioned.
So can you file at the CCMA without a lawyer?
Yes, you can file. So what you do, if you go to the CCMA website, there is a form titled 7.11. It's called a referral form. And the good thing about that is that it's free. You can do that, or you can actually, after downloading the form, you can easily fill it in and then submit it by hand at the CCMA, or fill the form online on the CCMA platform website.
Is it easier to fill it online or submit it physically? Which one is faster?
I mean, they have time periods by which they need to respond to you.
Okay.
Yes. So I find it very effective for both times as well.
Sorry. I'm sitting on top of a pillow, guys. I'm struggling with height.
Okay.
So I was born short, apparently, and I just grew shorter. I don't know how it happened. Yes. But due to cases like the share garage lady from Maitland,
yes,
who was actually forced by her employer to actually work outside as a petrol attendant, and they were questioning how could she actually afford a second-hand Honda when she's earning such a salary, and they asked to view her bank statements at the workplace. Her boss was going through her bank statements because he couldn't understand why she managed to actually get a car while she was working as a cashier at the garage. So stuff like that. Do you think it's necessary for someone to have labor protection insurance?
Yeah, I think that case, if I may delve into it, it's quite sad actually. That was highly unfair for the employer to do that to the lady, because regardless of how much is being paid, he has no business involving himself as to how she gotten about getting a car.
He's not SARS.
Excellent. If he wanted to make investigations or lodge investigations, he's more than welcome to do that. Lodge investigation, but should you not find anything, let it be. Now, in that particular order, we have what we call an unfair labor practice, as I've mentioned before. Unfair labor practice in that he gave her 2 ultimatums. It's either you are demoted into a patrol attendant or you resign. That's unfair labor practice because it's a demotion that is not written down to start with, which has no change in salary, or rather it will affect negatively her salary. Number 2, forcing her to actually now print out bank statements so that he could send to himself, and as I've read, he sent in his email. Now, that's against the POPI Act, Protection of Personal Information, because bank statements are private. As an employer, you have no business looking forward to getting bank statements unless really there is an investigation, legit investigation that is going on that needs the employee to actually discover bank statements. So in that too regard, her right to privacy as well was impaired by this employer.
Better sue the hell out of that guy, man. Go.
Yeah, I think she has a proper legal standing if she would go to the CCMA, even if it may enter to the labor court. I think she does have a proper
Even though
standing.
she was not really fired. Okay. Yeah. So the CCMA is not for when you're fired.
It's not only for when you're fired. We could be dealing with issues of promotions, where you felt that you are the most superior in qualification or reaching out to the requirements of the advertisement of the position, but you are still not chosen for the position. Others who had less qualifications that they're eventually been taken into the step. So you can approach the CCMA for that.
Yeah?
Yes.
Hi, man.
I am actually dealing with a case like that at the labor court right now, where my client, there was an advertisement that has been released in 2024, if not 2023. I will not mention the position for the sake of confidentiality.
Yes.
It was an advertisement that was taken out by a municipality around the province, but he could not be selected based on something stupid. And as we know, with municipalities, it's also politically influenced as such. But when you look at the qualifications and the requirements that advertisement for the position holds, he actually ticked all the boxes. But people who had lesser qualifications than him, they were taken and considered for the position. It is that by reason that we are at the labor court right now, reviewing the matter. It went to the arbitration by the bargaining council. We're trying to override that decision and have the client been taken for the position and have the other one demoted for it.
Okay, moving on. Yeah? This one, that's very interesting, actually. I didn't even know.
Yes.
But now that we're going to take this out, people are going to now start filing things against other people at workplaces because they are more qualified than them, but they are...
Well, they can bring it home. We can handle it.
How are you going to have a lot of clients from this one?
Yeah.
Let me not say anything, hey?
Yeah.
So do you think that it's necessary to have labor protection insurances? Back to that question.
I think it is. I think insurances are for the time when you really need them and you can't really afford to pay private lawyers' fees. I mean, if you're paying from 100 rand to 50, 500 every month, and then you have someone who can represent you, and when you really look at the size of the matter at that particular point in time, I would probably charge you 30,000 or so. If you're comfortable with paying 100 rand or 500 rand per month, I think that's quite beneficial for you as an employee.
So you think that people should definitely get it?
I think people should go for Benedictus Dlodlo Incorporated. They'll be taken care of well.
So do you have like a legal package for that, like for someone to pay monthly?
Yes, we do. We do
Okay.
for that. But of course, it's subject to limitation.
What's the price of the unlimited one?
Well, we do have our flat fees, especially if we have to go to the labor court, because the labor court is treated as the high court in terms of labor matters. So the standards is usually the same. So if you're going to charge you with regards to that, it's going to be a bit costly. But if we are talking about the Commission for Conciliation, Mediation, and Arbitration, that is CCMA, we do have such packages where you pay up to 600 Rand.
Oh, okay.
Because with arbitration, lawyers are allowed to represent you. It is only during conciliation where you have to perhaps find a colleague or represent yourself in that particular order.
Find a colleague to represent you.
Yes.
Why? Why would you want to get a colleague to represent you? What if they're the one that threw you under the bus? Are you going to find out there?
I mean, it's quite rare because you might find that they are also afraid that if they do represent you, because it's against the organization, they might be frowned upon on their return to work. Do you understand? But if you need to represent yourself at the CCMA, you are more than welcome to have colleagues as witnesses, since the whole issue might have happened within the workplace in that regard. So if you need to have witnesses from work, yes.
Wow, that's very, very interesting. So moving on to employment contracts,
Yes.
since we're still on employment. So employment contracts are legally binding agreements between an employer and an employee that set out the terms and conditions of employment. They protect the rights and outline the responsibilities of both parties. So what are the red flags that people must watch out for before signing these contracts?
Well, vague requirements of the contract.
Vague.
Yes.
What is vague?
Vague, where you are not sure what the requirements really are. So they are not transparent about your requirements in such a way that you really don't know what your responsibilities are, or they are limited to the scope. And if there's no limited scope in that regard, that means an employer can give you responsibilities that you are not even upskilled about. You understand? And then we also look at probationary periods. If they are not mentioned within your contract, you don't know when you'll be taken as a permanent employee. Usually we know that it's 3 months to 6 months. But if the contract doesn't mention, that gives a loophole to the employer to fire you at any time.
Wow.
You understand? We also look at where salary is not disclosed.
Yes.
Yes. I mean, there is no law that really forces employers. So let's say in their advertisement, before we go to disclose the salary when advertising a post. But we know that a good employer is very transparent. So if they are not disclosing that, then you know firsthand there is a red flag.
But I beg to differ there,
Okay.
and I know you're the professional in the room, and I'm the designer in life. But it's because the contracts normally have salary clause. So they normally tell you cannot discuss your salary with another employer. So if now they're taking out a job post and they're putting a salary there, and the employers within the company see, oh, people are getting 5,000 Rand a month and I'm getting 1.5. Why is that the case? Why are they advertising for the same role that I'm doing? Because it's open. Maybe there's another there's a lot of work to do, but they're willing to pay them twice as much as what I'm earning. And because of these salary clause. Is that not the case?
I think you've touched to a very sensitive subject when you're speaking about salary confidentiality. The basic conditions of Employment Act, together with the employment equity, they actually allow employees to discuss their salaries without the employers frowning upon them. We know the reason why they are being placed there, because it's, Section 6 of the Employment Equity Act, it says same work pay for same responsibilities. Now, if you discover that you're in the workplace where in the same position, you are paid 10,000 and I'm paid 20,000, that is discrimination, which is unfair by law. So the reason there are confidentiality clauses when it comes to salaries is that employers are trying to protect themselves in that regard. We don't know. It might be because of favoritism, biasness, or a racial thing.
Yeah, but there's also an article that was placed on the questions, if you've seen it, that other races are paid more and men are getting paid between 23 to 35% more than women in workplaces.
Well, that is something that I can't really say much about, But in my experience of employment, this is what I've noted. is that in my study of this, I've realized that it is usually men who are willing to take more overtime than women in most cases. You see, so if we're gonna raise issues of men and women being paid in disparities, we also have to look at the kind of results they are bringing to the table. If I'm an employer, I'd say as long as you're doing as good as a job as the other counterpart, definitely you should be compensated for it. And also, I don't think mentioning the issue of staying longer at work and all that, I don't think it's also the matter of staying longer at work, because you can still stay longer at work and still not give good results. Now, it may also bring to the attention to the employer to say that what is the use of staying behind so late and then being paid for extra hours, but you are not bringing good results within the table.
But now you're saying there's a loophole in the act you just mentioned about if we're doing the same work, we should get the same pay.
If
So I could be doing the same work as the other person, but because unfortunately they've got good looks and we are in sale, of course people are gonna talk to them. What am I supposed to do? Get cosmetic surgery to look better in order for me to like perform?
I think that's beyond the scope of what your employer may
But it's,
may say in
for example,
any way.
it's like it's sales, right? I work in sales, for example, right?
Okay.
And I don't look as good as you. You're muscular. I don't have muscles, right? So when the ladies come in the shop, they want to be helped by you, not me, because they're hoping maybe he'll ask for a number and whatever. But then we are both working, standing the same way every day, the same hours. I'm talking to people as much as possible, but still they're going to take that out to the effort. How is that fair?
I mean, at this particular point, what I would say, you just gotta use what you have within the confines of morality, of course.
But I don't have muscles. It's not gonna help. And I was born very thin. Irregardless of what I eat, I don't gain weight. You see, I think that's some form of discrimination. That should be some form of discrimination because
By who? By the employer or your customers?
the employer, we are all spending the same amount of hours.
Look,
We
it's-
working,
we
we
can
filing the
spend
paperwork.
we can spend the same amount of hours, but we're working on results here, not on the number of attempts. I can have 50 attempts, you have 100, and I still give more to the table. What now?
So now, does it change that same work, same pay? So it would be what? Results, good pay?
Yeah, of course. I mean, as an employer, if you're giving more results to the table, I'm more inclined to award you than the one who's...
Yo, so can salary discrimination get an employer in legal trouble?
It can. It's unfair labor practice and it's discrimination, which is unfair at that particular point in time. It can be taken to the CCMA for compensation to the victim.
And why are people scared to challenge employment contracts, especially because, SA's unemployment stats is sitting at over 50% for the youth? So what makes you think that people are scared of challenging those contracts? Hence, people are signing contracts without probation periods mentioned, without salaries being mentioned, with a lot of loopholes. Is it because of the unemployment rate or is it because of something deeper?
I mean, first and foremost, like you mentioned, that we have a high unemployment rate in South Africa. Your leg is not within the organization to start with. If you're going to start off by challenging a potential employer without your leg in, already they can see that this one is going to give us trouble. And others is for fear of unemployment. They would rather desperately take the contract and get into employment. And what I would advise is that first and foremost, you need to read your contract carefully or give it to a certain legal person to read it for you, because there are other legal jargons you may fail to understand, so that they put to you what you need to understand. And afterwards, you can then negotiate in good faith before you challenge the contract.
Negotiate in good faith.
Negotiate in good faith, at least.
So there's also another part that I've seen in contracts that's very, very interesting, the social media clause.
The social media clause, yes, it's quite important, that one. It's most companies, especially incorporated there, it's part of their vetting system. Because
I don't want to be vetted on social media, but okay.
I mean, it's unpopular, but it is one thing to say that your personal lifestyle may somehow jeopardize your work relationship somehow. I can give an example of where I could have an employee wearing the brand of a company, and it's been taken videos at Groove doing things that could be embarrassing.
But they went to Groove with the work T-shirt.
It's a work T-shirt,
They
but
forgot to change it.
what if they misbehave? The name of the company or the brand of the company is there.
What happens?
If this thing has to be reported somehow, the name of the company will be dragged in.
I think I'm going to argue with you too much today. But there's this thing called PR. There's no such thing as bad publicity. So if, for example, your company sells watches and I'm wearing a T-shirt of a watch and I'm dancing all over the place and people are taking me videos and it goes viral and your sales go up.
I think that's my problem with the statement of there's no such thing as bad publicity. It just depends on how you manipulate it. People lose sponsorships simply because of allegations without any investigation. And if you say there's no such thing as bad publicity,
that's the
bad
statement that I
publicity.
found when I was born. I did not make it up.
So I think there is bad publicity.
But I'm saying in terms of the company, I'm wearing a T-shirt that says I sell your watch, right? We've been down for sales for months. And I'm dancing there at Groove. Someone decides to take a video of me dancing and I'm drunk. And of course, being drunk no one wants to be associated with a drunk person. No company wants that, right?
Okay.
But now your sales go up.
My
And then
sales
you
go up.
fired me. Can I still sue you now? Because I gave you publicity that helped your sales.
No, you can't.
Huh?
Even if you sue me, I don't think you'd have high chances of winning regardless.
So I lose my job
Because
and you gain,
for the dignity of the company, you are not supposed to be there wearing that brand.
regardless of whether it's good for the brand or not.
It's really up to the company to do that. If you're lucky enough for them to say that they want to thank you, to say congratulations.
But if they decide, you know what, your drunk behavior because there were 20 bad comments and but jiggy, everyone is wearing your watch,
Exactly.
then it's a loss for them.
It could be a loss for them.
So how does one navigate a social media clause?
Well, by navigation, what do you simply do? You mean like to manipulate it or what?
You know, in contracts, every time you sign them, as much as they put a lot of legal jargon in it, they also leave loopholes for themselves as well. It's how it is. There's always going to be a loophole. There's always going to be that
Definitely.
clause that does not make sense in the contract, that even if someone tries to fire you with it, someone tries to fire you with another clause, you can actually use it as a loophole, right? That's what I was taught, that every time you sign a contract, always make sure it has a loophole that you know later, my employer's going to listen to, that you know later you can manipulate when things go wrong. So now, around the social media clause, can it say, can you manipulate it to or negotiate for it to say subjected to 1, 2, 3, 4? Because if you're making sales out of me or dancing with my T-shirt on TikTok of your company and now you've got followers, that's unfair that I'm getting dismissed because I was dancing with a shot and you guys are all about cover up, body positivity or whatever the case might be. So how can one go around it? I'm sure there's a legal way.
I think that is subject to argument whenever the issue arises. But I think each and every organization wants to put themselves in a stance where their reputation is not undermined. You understand? It could be a simple thing where I'm actually seen wearing a brand of a particular company, where I'm engaged in a fight without then having to look at the fact that I was defending myself or whatsoever. There could be unjustified, or rather say justified dismissals in that regard. It may sound a bit as if it's unfair,
Very
but it
unfair.
has happened. There have been cases such as that.
I've also heard about a case where some ladies went out with their work uniform during lunch and then took a drink or two, and then someone captured the picture and sent it to the company, and then it became a thing.
Yes.
Is that even, what is your lunchtime? Isn't that your hour? Or are you still on the job in a way?
Remember, your lunchtime, you're still at work. You're just on a break. It's not after work time. So whatever happens in that regard happens. Sorry about that.
Okay, guys, we are serious. Just someone is, are you okay there? Are you good? Would you like some water? Oh, okay, I'm just making sure. Okay, so what and when are background checks performed, and what are they for? Why is it important for employers to perform background checks?
It's also for the reputation and the dignity of the organization. You want to know who you're hiring. It's basically on a character check. which this can be done individually or via SAPS, or there are also other softwares that can be used.
Softwares?
Yes, for the sake of confidentiality, we're not advertising them now. But it doesn't, it doesn't even cost much to do that. So background checks for criminal records, for credit checks. Your employer wants to know how do you behave with your money at that particular point, and for referendum at that particular point in time. If you say perhaps in interviews that you work for these particular companies or organizations, it will show as well on that particular platform.
Oh, okay. So now it actually brings a very, very interesting side, right? Can an ordinary person do a background check?
Yes. The softwares that I've talked about, you can even register them yourself. It doesn't take a lot of money, simply 100 Rand to a 500 Rand. You can pull someone's personal information as long as you have their ID number.
Or is subjected to having their ID number.
Yes.
So if an employer decides to hire someone with a criminal record, is it within the other employee's rights to know?
Well, both parties actually have a responsibility there. The employer has the responsibility to find out what kind of a person he's employing. Also, the employee, or the potential employee rather, bears the responsibility to disclose that. Because if in any case eventually it's being found out, he may get dismissed, which will be fair at that particular point.
Okay.
Let's say you're employing someone at a financial institution and this person was arrested for fraud at a particular point in time.
That's a bad idea.
That's a risk. That's a potential risk you're already facing there.
But while we're talking about work environments, let's move on to toxic work environments. How do you know that you're in a toxic work environment?
I mean, any conduct that may impact the dignity of an employee. It could go back to being harassment, could go back to being a certain form of abuse, whether verbal, digital, or in any other form, thereby creating an uncomfortable environment that sort of also impairs your progress at work in that particular point in time.
So now, when you're collecting evidence, because you're going to need it when you go to the CCMA, right, to
Yes.
show that this employer was actually toxic or this environment was actually toxic.
Yes.
So how do you advise our audience to go about investigating and collecting that evidence in a way that it would be admissible in court? Because sometimes you can collect evidence, but it's not admissible at all.
Yeah.
So
Emails, you can have if it's a work laptop, you can have access to emails. WhatsApp messages, voice recordings, videos can also be used and be admissible at court.
But how is a voice? Because I've heard that, how is like those recordings admissible? Because I've heard someone say that if you're not part of it, it's not admissible.
If you're not part of
If you're not part of the voice note for the recording of that meeting and it's recorded and somehow people are talking about you and it's really, really bad and it's racist or whatever the case might be, but you're not part of that record, someone said it's not admissible in court.
It is admissible. What if you're having someone as a witness who actually recorded this?
But what if the witness doesn't want to come forward?
Well, that's another thing. Then
that's when it's not.
Yeah. But if you have a witness who's willing to come forward, who was part of the conversation, then it is admissible.
Okay. Then there's social justice and economic development. How is economic development implemented in the workplace?
We have skills training.
Skills training. Okay.
Skills training and development at workplaces where you upskill your employees. To work with different training programs. It could be apprenticeship. It could be what do we call this? Mentorship as well. Where as long as anything that would actually upskill the employees in order to bring about the development of the organization in that regard works. And we can also deal with promotions. Most employers, it boosts their morals when, in most cases, when a position is advertised and the priority of that position is taken first internally rather than considering outside people. Then employees tend to understand that at least there is growth for the people inside rather than just opening a position and then you're looking for an outsider. Then outside, when you promote people from within the organization, they become loyal to the company as well. And then we have employee ownership scheme, where the company provides a stake of shareholding to employees. So whether we choose to say this 20% is given to the employees, we know that as an employee, if you put so much effort within an organization in that regard, you are working to develop the organization, in which in turn it will benefit you financially. So that's how it works. But that part is for employees. Now, when it comes to organizations themselves, the first part will be to, let's say for instance, to digitalize their company. If, let's say, you were working on paper, you choose now to go digital. It creates competitiveness within the organizations out there. You understand? So that means you'll be working faster and efficient in any matter in that regard. And also compliance of organizations. Every organization has a regulatory body that they need to comply with, failing which they might face penalties, and that could actually jeopardize the dignity of the company in that regard. So that's how the development can take place.
Wow. Okay. But also people have this myth that, HR is there to protect the company and it's acting in the best interest of the company rather than the victim, whether it's someone that's being treated unfairly at work or harassed at work. Why do people have that stigma?
I think I've got a bit of a little joke regarding that. On my previous employment, we used to have a slogan when it comes to HR. We say, human resource where careers die. You understand? So in that regard, I think people forget that HR personnel, they're employees themselves who are hired just like everyone else. And the painful part about it is that the HR personnel sometimes take decisions that they themselves, if they would voluntarily take upon, they wouldn't have arrived to the conclusion of where the matter is set. If, for example, we have now an employee who is not liked by a director or a senior of some sort, and yes, perhaps there is a misconduct that only warrants a warning. If now the HR is being forced to say, look, we have given you an instruction to fire this person, they have no other means as an employee but to adhere to the instruction of their seniors. There could be repercussions regardless, but in most cases it's that HR is actually there to look towards the interest of the organization. They prioritize the organization first as opposed to other employees.
Does this also make them complicit to companies that hire illegal immigrants in the SA?
There could be, but also must remember that there would not be any punitive cost when it comes to them personally. It will always be the organization that gets punished in that regard. Like I mentioned, HR personnel, employees as well, they take instructions rather than just acting in their own accord in most cases.
So these people, when they get hired, is it on a formal contract or not? Can they get, if you're an illegal immigrant,
yes,
when you get hired, are you given any a formal contract, or you just work with word of mouth?
Well, I can't necessarily tell if there is. As an illegal worker or person, regardless if I may put it in that term, employee, it is the employer has rather a responsibility to vet whoever that is going to fire. If this person doesn't have a permit within the country, therefore you know very well as an employer that you shouldn't hire this person unless they are compliant. So in situations, however, where an illegal person is actually hired for a particular job or for a particular employment, they are still protected under the Labor Relations Act and the Employment Services Act. Because if there's no contract, if it's just verbal, we still have to establish the relationship between the two. If there was a relationship of employment and employee, then they're still protected in that regard. And they can still go file at the CCMA.
Even without documentation?
Even without documentation. Exploitation is punished in our law.
Okay, so we are running out of time, but we need to cover a few more things.
Okay.
So workplace relationships.
Okay.
Law and mjolo. Let's see how that actually combines. So are we going to refer to like the Nedbank dating scandal scenario? I'm sure you've seen it.
Not precisely, but yeah. But I do have my opinion on that, yes.
Yes, and then they say that plus 57% of workplace relationships end up in marriage. How can couples protect themselves in workplaces?
I think you...
I'm not dating at work.
Disclaimer.
Yes, yeah. Before I get under investigation, no one.
I think the most important thing that they could do to safeguard their interest there is they should let their seniors know about it. They should disclose it.
After 2 days, you're already disclosing.
I mean, if you guys are serious about each other, it's safe to... What if it's a relationship based on a senior and a subordinate? It's unethical. So disclosing now removes the stance so that there shouldn't be anything that is suspicious when it happens. Now it could go back to a stance that maybe, for example, something happened to you at work, or you did something that is unfair and your senior didn't punish you for it. And then they found out that actually these ones are kicking it off. Already it creates certain,
Oh my word. Yeah, so okay.
Yeah.
Hi.
But I think advice would be like, these parties, if they're really serious about each other, they should disclose it to
Even
the organization.
within the first 24 hours, ne?
Definitely.
But within the first 24 hours, guys, literally, nah. So, there was another interesting part that you also wanted to touch on, which is road accident funds,
Yes.
that you were very interested in touching on. So, it says REF is a public insurance scheme in South Africa designed to compensate people who are injured and whose dependents are killed in the road. Killed in the road caused by the negligence of another driver. So why do people get scammed by lawyers when they apply for road accident funds? I'm sorry, I know you're a lawyer and you're not scamming anyone, but we need to ask.
I mean, it's basically just unscrupulous lawyers, lawyers who work in bad faith and they're crooks. There's no other thing to explain apart from that. I mean, when you're a lawyer, you're supposed to function with integrity. You need to be ethical. But of course, with the love of money being the root of all evil, they pry on the ignorance of their clients.
So I saw a news clip, right, online the other day, and I was shocked. It says that illegal foreign nationals, if they get into an accident, do qualify for REF.
Well, to a certain extent. Again, road accident funds only pays to people who are legally within the country. But however, there have been cases that have been challenged with regards to that, where we found that illegal immigrants, they end up getting paid for that at that particular point in time. So it's basically, you can be here temporarily or whatsoever, but there is a way around it, because what I've noticed with the South African law is that it's too sensitive when it comes to personal rights rather than anything. So there have been cases that I've also worked on as a candidate attorney where someone was an illegal, person, but somehow still managed to benefit from the state funds.
Wow. So how does REF catch on fraudulent or self-inflicted accidents? Because some people just throw themselves right in front of the car in hopes that, you know what, I will live and I will be a millionaire. And then we see them at I blew it and then jiggy.
I think apart from surveillance, also what the road accident fund still uses the SAPS investigations to find out where the accident occurred. If there are any cameras, they'd really want to have access to them and see if there are any witnesses. They'd want to access and see that. So claims don't just happen automatically. There are investigations that take place before now a claim could be said to be a valid claim.
And people want to know about money. So what's the minimum amount that REF can pay out?
There is no calculated minimum amount.
What's the lowest it has paid?
I can give you a breakdown of what it takes actually, or what determines the kind of pay, right?
Okay.
Now you have a Mr. Dlodlo who is a business person. He earns 500,000 a month, and he gets involved in a car accident. Let's say, for instance, to make this example easier, he's a passenger. Gets into an accident. What now the road accident fund will look is with the injuries, depending on the severity of the injuries. If it's such in a state that now I can no longer function as an attorney, there will be what we called a past loss of earnings and future loss of earnings, calculated from the date of accident up until retirement age. And also there'll be past loss of medicals, right? And the future medicals. So there'll be medicals, they'll calculate the medicals, that medication amount, if I may put it, that I'll need to spend in order to take care of myself from the moment of injury up until, right? And then also there's
Now I see why people do it.
yeah, and then there's also what we call general damages. General damages are based on pain and suffering. You get compensated for that. So people who get the highest are people, for example, with fractures, head injuries, amputations. Those ones are the people that get. Also, your qualification counts. If you have qualifications, the calculations would say, based on the standard of education this person has, if you were a doctor, we also calculate potential promotions that may take. That's why there are so many medical practitioners that take part during that part. The reports of medical reports, like your industrial psychologist, if you were employed as well, neurologist, neurosurgeon, all those things are compiled. And then the one who makes calculations at the end, it will be the actuary. So the actuary will actually base those calculations involving all that which I've mentioned and then come up with a stipulated amount. The highest that has ever been paid in South Africa, according to my knowledge, is a guy from Switzerland who was a businessman who came to visit the country legally and got into a car accident. And they had to compensate him in accordance to the monies, which I don't know what is called in Switzerland. But in rands, it was calculated over 500 million.
It's fine. So he came and got 500 million from South Africa and left.
And he left.
Yeah, guys. Okay, that brings us to the end of our segment.
So it was.
Oh, sorry.
So it was calculated as per currency of Switzerland. That's why the money, when it was paid, that it was that.
So do you want to tell our audience a bit about your business, how they can contact you and all of that before we close?
Oh, yes. Our email is admin@benedictusdlodlo-inc.com, or you can call 064-072-4121. Or you can log on to our website, www.benedictusdlodlo-inc.com. Thank you.
Great. And guys, that is the end of our legal segment. Very, very interesting. Please do not be jumping in front of moving cars because of the knowledge we just shared. That is not the point of the podcast. But anyway, don't forget to follow us on all social media platforms at S4EP1. And please don't forget to subscribe. And we will see you next time.